Honorable members, good morning once more, and good morning to the team from the Special Investigating Unit. You almost need no introduction. Mr. Klesibe and Mr. Lekgeto, good morning, and thank you very much for being with us today, and good morning to the Office of the Auditor General and our colleagues here in Parliament. Today is a follow-up to yesterday's proceedings. Yesterday, we had the Auditor General's Office briefing the committee on the audit outcomes of the financial year that ended 31st March 2024. And they covered the National Department of Water and Sanitation and also entities that fall within the ambit of the department. What we did not take a presentation on is the regional water structures, that is the water boards and so on. Today, we have the Special Investigating Unit to update the committee on its investigations relating to water and to the water and sanitation sector. That specific term is very important because in this update today, even though we have not yet taken presentations on water boards, this presentation will involve the water boards so that we can also make efficient use of the SIU's time so that they don't have to keep coming back here on the same theme. So they're going to present to the committee on their investigations into the water and sanitation sector in general. So there's quite a number of proclamations that fall therein. They will be updating us on investigations or proclamations that have completed and proclamations that are ongoing. So I will hand over to you. In fact, I also need to recognize, because we received the communication ahead of time, that Advocate Motibi is busy with G20 matters. Everybody is busy with G20 matters because we are the host on this occasion. South Africa is the presidency of the G20, so a lot of government officials are involved in that work. So we have acceded to the request for Advocate Motibi not to be here. It's not out of lack of regard and respect for the committee at all. So I will hand over to you, lady and gentlemen, to proceed. Thank you.
No, thanks, Honourable Chair, and thanks, Honourable Member. Thanks for the welcome. And like you've indicated, that Advocate Motibi is not here. Myself and Ms. Klesibe will do the presentation, and she will start, and I'll come in at the end where I'll present certain portion. So without wasting time, I'll hand over to Ms. Klesibe. Thank you, Chair.
Thanks, Dr. Lekgeto. Good morning, Honourable Chair, Honourable Members. Okay, Chairperson, in the interest of time, we are not going to be, I will just move straight to slide number 8. Slide number 8 is just to give an overview of all the matters that we investigated in the water and sanitation sector. Over the years, Chair, from 2008 to date, we have received 14 proclamations relating to the water and sanitation sector. Out of these, 9 proclamations, investigations into 9 proclamations have been finalized. We do have active proclamations, and those are only 5. So we had, in terms of the active ones, we have R82 of 2022, which is Lepelle Northern Water Board and Amadola Water Board. Number 2 is R96 of 2022, which is Grootfontein and Grootdry Pump Station contracts. Then the third one is Proc 138 of 2023, which is Rooiwal Wastewater Treatment Works at the City of Tshwane Metropolitan Municipality. The fourth one is R164 of 2024, which is then the matter on the war on leaks. And then the last one that we received this year is R248 of 2025, eThekwini Metropolitan Municipality, Water and Sanitation Services. The completed proclamations, Chair, would be those ones, R35 of 2008 relating to Umhlatuze Water Board, and then R54 of 2012 relating to the Department of Water Affairs in the Vuwani area, and then R22 of 2016, which was then relating to the LTE consulting by the Lepelle Northern Water, which is in Guyana, and also the Gauteng Department of Human Settlement. This proclamation was extended by R27 of 2019 to include Blackhead Consulting. Then the fourth one is Proclamation 27 of 2018, the awarding of contracts by Department of Water and Sanitation to the subcontract, and then which was also extended by R44 of 2019. Then the fifth one is R28 of 2019 relating to Tukela and Hotetro Water Scheme. And then the sixth one being R4 of 2019, Umgeni and Utukela Water. R23 of 2020, which was the COVID-19 relating to Amatola Water Board. And R33 of 2021, which was like the 4 contracts that were awarded to EOH. And then R122 of 2023, again on Umgeni Water. Umgeni and Utukela Water Board. So those were the proclamations that we received over the years. Then, Chair, we thought maybe it would be important to at least brief the committee on the cross-cutting trends and patterns in the sector. What we have observed as trends in the sector, Chair, would be the fact that contracts would balloon from the initial budget. There were irregular appointment of service providers. There's also contravention of Section 217 of the Constitution. The contractors were, that failed to perform in terms of the contract, irregular contract extensions, procurement irregularities, SCM processes that were not followed, possible fraudulent claims that were paid by the water sector, overpriced goods and services, payments for work that was never performed, treasury regulations that were contravened, manipulation of the payment system, of overpayments and incorrect VAT charges, and then officials of the water sector that certified and commissioned work that was not performed. Then there was already issues relating to incurring of irregular expenditure, and also then in terms of our processes, we also observed the missing procurement document and information. Then, Chair, we are now going to be just giving you highlights on the active proclamation. Chair, you will notice that we have provided the committee with both the detailed presentation, and this is just the short version.
Sorry, Ms. Klesibe, I wanted to assure the members who may have been able to vote in 1994 that AWB stands for Amatola Water Board, not the Afrikaner Weerstand Beweging of Eugene Terry Blanche, just to be certain. So the AWB was not is not an arm of government. That AWB. Sorry, Ms. Klesibe, please go ahead.
Thank you, Chairperson. Chairperson, before I start presenting on these active proclamations, I think I need to maybe apprise the committee on our reporting format. Normally, when we report to SCOPA and to any other committee, we felt that it's necessary to bring the committee and into board in terms of the allegations that we receive as SIU. So it does not mean that, when we are talking about the allegations, the column that deals with allegations, we are making any founding or making any statement on the allegation, but it's just to inform the committee that our investigations were in relation of the allegations that we received. So in all our presentations, Chair, you will notice that we will give you at least a preview of then the allegations that we receive. So in terms of Amatola Water Board, there were allegations relating to draft relief technology services and also the investigation services. And this contract, it was alleged that Amatola had appointed the service provider that was appointed by the Lepelle Northern Water Board, and the allegations were that, Amatola then contravened Section 217 of the Constitution. Also, there was an allegation that there was a 230 million rand that was allocated to Amatola Water Board for draft relief solution, which therefore, out of this, 60% was earmarked for drought relief technology service provider. The procurement of both services was not budgeted for. Those were the allegations that we received. In terms of our findings, in terms of the Amatola, which I must report, Chair, that whilst Amatola Water Board investigation is complete, the Lepelle Northern Water is not, which I'm going to be reporting, and both entities are under one proclamation. What we have established, Chairperson, that is that there were irregularities in the appointment of the company called Empowerment Water Solutions, the company that was appointed for sand and water extraction services. There was a feasibility study that was conducted in certain areas of the Eastern Cape, and the conclusion was that there was no sustainability in the identified areas for sand and water extraction. The contract then remained open, because the entity was actually appointed and a purchase order was issued. So what we then did, because there was no work done in terms of this, and we advised the Amatola Water Board that the purchase orders to the value of that 17.4 million to be cancelled, and therefore saving then the institution the same amount. Then there was also then the issue around the procurement of water cutting services in respect of 62 service providers. We have investigated these matters, and we found no irregularities in relating to 53 matters. And then in this instance, we have referred 38 matters to the NPA, and then the evidence that we referred was pointing to fraud, forgery, and uttering, with an aggregate amount of 14.1 million rand. Then, in this regard, Chairperson, we are also considering civil litigation in order to recover these amounts. So we are also contemplating on either to litigate ourselves through special tribunal or to refer these matters to the AFU, because there is fraud. We also referred 3 disciplinary referrals to the Amatola Water Board, and these relate to 3 SCM officials, and that were part of then the procurement process, and then the misconduct in the appointment of 33 service providers. Then I moved to R82, same proclamation, but now in relation to Lepelle Northern Water Board. The allegations in this area was the appointment of the service provider for civil engineering management contract, the appointment of service provider for testing and piloting of sand water extraction technology, the appointment of service provider for financial position investigation contract. Then it was also conducting a value for money exercise and overpricing relating to the refurbishment and construction of boreholes at Moudze area. In terms of our findings, Chair, the appointment of service provider for the engineering and management services contract, that appointment was found to be irregular, and subsequent contract extensions were also irregular. So that is our findings, summary of our findings. Then in the second one, where then the sand water extraction technology, the single source appointment of a service provider found to be irregular as well. The goods and services on the sand water extraction technology contract was found to be also overpriced. Then the appointment of the service provider in terms of then the financial position investigation contract, in terms of Section 45 of the Water Service Act was found also to be irregular. Then in terms of the last one, the civil engineer is in the process of drafting an interim report to advise us exactly what is the finding on the last one. In terms of our outcomes, we have referred 8 disciplinary referrals, 3 BEC members and 4 BAC members and 1 SCM officials. And in terms of then the outcomes, we have then been advised by the department that there was 1 final written warning. And then in terms of 4, there was no prospect of successful prosecution. So then, therefore, the department did not implement our recommendations. We are currently pursuing a matter to the value of 107 million rand. That's our civil litigation unit is currently busy with that. It has gone through the assessment stage. We are preparing to lodge this one at the special tribunal. Then the processes are underway for further disease and civil litigation matters, and we are busy with the right of replies.
Sorry, may I interrupt? Please stay on the same slide. Can you just give us a bit more color on the 107 million? So what had happened? Had the money been paid over to the supplier? Can you just explain what the story is with the 107 million?
Yes, that's the money that has already been spent in terms of the contract, Chairperson. And now we are in the process of, we are assessing that contract because we have made findings, and now we are in the process of approaching special tribunal for the recovery of that money.
Okay, thanks, Ms. Lepsib. So just so that it's clearer, so can you just set out the story here in simple language, so that it's easy to understand? Because unlike so this is a specific area that we haven't dealt with before, and it's also not easy to understand for the public, because a building is easier to understand, or a road and so on. In this case, what was supposed to happen and why did it cost so much? So what were they supposed to provide? I know it says for testing and piloting of sand water extraction technology, but what was it they were providing? Is it machinery? Is it actually extracting water? Can you just describe the work itself and how the money came to be paid, and therefore, so that we can understand why you are pursuing civil litigation as a SIU?
Thanks, Chairperson. In this instance, Chair, it was a technology. It's an entity that provides technology to, in response to the drought that was declared that period. So this is the technology that gets tested. You go to certain areas, and then it's actually the feasibility study for areas that could then be tested, like, for instance, I would think of Eastern Cape. It was like done in Matatiel, and then the feasibility study, the conclusion was that there's no way that, water could be extracted there. So they would then test this IT, this technology, to see if then they could be able to, other than the normal borehole, but now it's some kind of a technology that would be used to check those areas where water could be extracted in a more tech-savvy way. Chairperson.
Okay, and then so what was the problem? Was it that this technology doesn't do what it says it does, or was it a mere duplication of the? I just want to understand the basis of pursuing the claim, because it's an area that we haven't dealt with before, so it's not easy to follow.
Okay. Remember, Chair, this was just a study. They would go to areas and then try. It was a trial and error situation. They would try here and there, and then in some areas there would be positive results, and in some there won't be any positive result. But the expenditure relating to this exercise, we felt that the entity paid more than it would have paid for. So, and even for the areas where there was no extraction, then it seems that the water board actually paid for that expenditure.
I see. Okay, so basically the water board ended up paying 107 million for work that should actually have cost far less than the 107 million. One. Two, there were instances where they invoiced for work that did not appear to have been done in the manner promised.
I think that's correct, Chair.
Okay, now I get it. Okay.
Then I'm moving now, Chair, to the Grootfontein and Grootdraai pump station, which is R96 of 2022. The allegations were the appointment of service provider relating to the contract, which was called DEV 0043 WTE. And then there was also repairs to the pump number 5 at Grootfontein pump station. And then the design, supply and installation and commissioning of packaged water treatment plant at Grootdraai pump station. Then we're also supposed to identify any unlawful conduct on the part of the department's officials or third parties. Our findings in this regard, Chairperson, are that the service provider was appointed in contravention of 217 of the Constitution, and various procurement irregularities were also found. There was also possible fraudulent claims paid in respect of the repairs of this pump number 5 at Grootfontein pump station. It appears that the service provider was paid 1.1 million rand for work that was never performed. There was also possible manipulation of payment system that might have resulted in the creation of purchase orders after the expiry of the contract. The department also incurred potential irregular expenditure by effecting 2 sundry payments of 12,000 and that 3,000 respectively. The officials also certified and commissioned work that was not performed, resulting in possible irregular payments. So in terms of then the outcomes, we are pursuing the matter in terms of our civil litigation unit, and we are our quantity surveyors are quantifying the actual claim. We have 3 disciplinary referrals that we have now. We have referred to the Department of Water and Sanitation, 1 against the CFO, the procurement manager, as well as then the manager at Standardton. We also have criminal cases registered by DWS. So in our instance, we just supported then the criminal matter in terms of this one, because the matter was already reported. In terms of then the last one, Chair, is the matter has been referred to the civil litigation to set the contract aside and recover all payments, cutting across all SIU findings on these focus areas. Then the next one is the Rooival wastewater treatment works at the city of Tshwane. There were two major focus areas in terms of this. It was the procurement investigation. Phase 1 was the upgrade and urgent refurbishment of the Rooival wastewater treatment works. And then the second one was the corruption investigation. No specific allegations of corruption were received. In terms of our findings, the contractor for phase 1 failed to perform and eventually abandoned the site, and the municipality terminated the contract in July 2022. There are no allegations relating to the remaining 3 contracts. So, because our main allegation was to investigate the very first contract for phase 1. The SIU identified 65 role players for high-level profiling, which is officials, private individuals, and entities. 9 officials were red flagged for further lifestyle analysis due to assets purchased and/or the fact that they were living beyond their means. 27 officials were also red flagged for further lifestyle analysis due to asset purchased and/or living beyond their means and/or suspicious transactions. In terms of the outcomes in this area, Chair, we have already referred 4 evidence in relation to 4 matters with regards to fraud and CITB non-compliance. We had 1 referral to SARS with regards to the SARS non-compliance. We also had 1 referral to CITB with relating to then the non-compliance with their standards. And we also had submitted a presidential report in terms of this matter, the interim presidential report. We are currently busy with the right of replies in a number of matters relating to the officials that we have now, we have reported to have red flagged. Then Proclamation 164 of 2024, which is a matter also that is still ongoing. The Department of Water and Sanitation dropped the block, War on Leaks, almost empty outdoor campaign. In terms of then the focus areas or the allegations, there was an expenditure of 500 million relating to the Drop the Block project. Then the other one was the almost empty outdoor campaign for 10 million rand. And then the third one was the War on Leaks program, which costed the department 2.2 billion. The first one, Chair, the findings of the SIU is that the service provider appointments were done by the Lepelle Northern Water, and thereafter the contracts were ceded to, what is SW? Okay, the contracts were ceded. I'll just check, Chair. I just forgot then the abbreviation. Then the proclamation, Chair, is limited to the contract with then Sedibeng Water. My apologies, Chair. And the SIU drafted an extension to the proclamation, which is currently in the Office of the Presidency. The investigation is focusing on the reasons and procedures followed in the cession or the transfer of the contract from Lepelle Northern Water to Sedibeng. So in this instance, the investigations are still ongoing. Then the second one, Sedibeng Water was appointed as an implementing agent contrary to the legislation and the Department of Water and Sanitation policy prescripts. They appointed the service provider using a deviation from the procurement process by going through an emergency procurement, which was irregular. Then we also identified irregularities of an overpayment and incorrect VAT charge, and in the invoices that Citibank submitted to the Department of Water and Sanitation for services. So we have already identified a potential cash recovery of 1.5 million rand there. In terms of Water on Leaks program, the approved budget amount was 2.2 billion, but the team has identified that 4.7 billion was paid out thus far. This number is still growing with the SIU's forensic accounts quantification process. A total of 1.7 was paid to Rand Water, which includes 40 million rand in unexplained and unsubstantiated contingency fees. This investigation is still ongoing, Chairperson. The last one being then the eThekwini Metropolitan Municipality, the R248 of 2015. The allegations are the provision of water and sanitation services to human settlements and schools situated within the municipality boundaries of the municipality in terms of project number Y6525AZ1, ablution blocks, in situ upgrade, infrastructure sanitation. This proclamation was recently published, Chair. The SIU has completed the setting up and scoping phase. Then now the investigation has commenced. No findings as yet. The investigation is currently ongoing, Chairperson. Then, Chair, we just felt maybe it would be important to apprise the committee on the impact of the SIU investigation on the water sector. This is just the summary of all the outcomes over the period 2012 to date. In terms of potential cash and assets to be recovered, we have got 264.1 million rand. Actual cash or asset recovered, it's 569.1 million rand. Contracts or administrative decisions set aside or deemed invalid, it's 1.1 billion rand. Potential loss prevented, it's 717 million rand. Rand value of matters referred for the institution or defense or position of civil proceedings, we are now sitting at 6.2 billion rand. Referrals to the National Prosecuting Authority, it's 270. Referrals for the disciplinary action against officials and executives, we've referred 71 matters. Referrals made for administrative action, we have referred 69 matters, Chair. Then in terms of then the preventative measures, we, as part of our investigations, Chair, we normally identify what could have been avoided, what are the weaknesses in the systems, and then also recommend certain remedies to fix the system. So based on the findings during our investigation, the SIU recommended that the following systemic improvements be made by the departments, and this has been shared with the department. We've recommended that all entities about to conduct business with the department must be registered on a formal supplier database and must supply the department with a letter of good standing with SARS prior to conducting business with the department. The department should perform CIPC checks on all of these entities to check for any employee involvement and or conflict of interest. Suppliers applying to be registered on the department's database, as well as the entities already registered, should complete the prescribed form in which any potential conflict of interest and or relationships with public officials must be declared. Then we also recommended that amendments to tender evaluation documents should be a requirement to be signed off by all regional bid adjudication committee members. Then committees dealing with the evaluation and awarding of tenders are to ensure that any such declarations made be formally included in the tender evaluation and adjudication processes. A circular should be communicated regularly, e.g. quarterly, alerting all staff to the provisions of Section 30 of the PSA, as well as Section 17 of the Prevention and Combating of Corrupt Activities Act. Authorization to perform remunerative work outside the public service should be kept centrally in a safe custody. A database or register used for the declaration of interest should be shared with SAM divisions and be regularly updated and inspected. Entities in which officials have business interest must not be allowed to do business with any government departments, as it may well constitute contravention of the PACOCA. And the department should take note of the prescribed threshold determined by the National Treasury and ensure that the provisions thereof are implemented and approved at appropriate levels. I will pause here, Chair, and then allow Mr. Lekgetho to take us through then the establishment of the water sector in anti-corruption forum.
Thank you, Honorable Chair and Honorable Member. This one I'm presenting is the Anti-Corruption Forum, where I think we've presented previously that we are looking, as part of our preventative measure, we are creating the forum in the sense that we are looking at the whole society approach in terms of the fighting of corruption. As we know that fighting corruption cannot be the only responsibility of the law enforcement. We really need the whole society in order for us to come together to fight corruption. Then on the water sector, we have identified the water sector also as one of the key sector which is really vulnerable in terms of the incident of fraud and corruption, where we look into it in the sense that when we foster collaboration from various stakeholders, that's the only way we can be able to fight this corruption. Then in terms of the key objectives and the terms of reference in terms of this forum pertaining to the water sector, we are looking at the objective is to support the anti-corruption initiative in various sectors that are vulnerable to incident of fraud and corruption. And we are looking at fostering collaboration amongst the stakeholders in the sector in order to effectively fight corruption. And we are looking at coordinating efforts amongst all law enforcement agencies to ensure that investigation capacity is in place. In that way, we trying to work together. And we also ensure that the outcome of such as criminal prosecution, civil recovery, and any administrative action are achieved. And lastly, we like to ensure that prevention measures are implemented to mitigate fraud and corruption risk in the sector. Then, normally in the sector, the approach that we do is we get key stakeholders that will be important for us to enable to do these things. In terms of this one, the key stakeholder are the law enforcement agency, Chapter 9 institutions, civil society, private sector, and the regulators and the private sector, and municipality, traditional and regional sector, and organized labor. So we bring all of them together. We are having meeting on a quarterly basis where we come together to check progress as to what is happening in terms of the allegation. Then in terms of the forum that has already been established, those are the ones that we have established to date. The first one is the Health Sector Anti-Corruption Forum, which was successfully launched on the 1st of October 2019. And then we have the Infrastructure Build Anti-Corruption Forum. Also, this one was launched on 25 May 2021. And we've got the Local Government Anti-Corruption Forum. Also, this one was launched. Then we've got Border Management Immigration Anti-Corruption Forum, which was also launched recently on the 25th of May 2025. Then what we did, Chair, since some of this forum were launched quite a long time ago in 2019 and 2021, so we decided to appoint an independent service provider so that they can evaluate the impact of the forum so that we can able to see whether is there any value that we are getting out of this forum. And the results show that the anti-corruption forum are effective with few recommendation. Example, improve turnaround time to deal with cases referred to the forum, and which also included relevant stakeholder to the forum and communicating or reporting channels to the forum. And it also highlighted, develop the implementation plan for respective forum to ensure, to enhance corruption preventive initiative. So that's the assessment that we did based on those forum, but we are still continuing in terms of implementing this preventive work of establishing the forums. Then progress on the establishment of the Water Sector Anti-Corruption Forum. This developed after we had a meeting with the Minister of Water Affairs, which was on the 21st of February 2025, where we indicated to her that we have identified water as one of the key sectors that is really vulnerable based on the allegation that we have received and also the amount of matters that we are litigating. So as a result, the minister recommended that he really wants this forum to be implemented in the water sector. As a result, we drafted the implementation plan and we engaged the department in order to get all the relevant stakeholders. Then there's also terms of reference that we have drafted, which we adopted. And also this sector, Chair, we can indicate that we had an inaugural meeting, which was done on the 14th of May for the Waters Anti-Corruption Forum. So this is how we continue in the site while we're trying to make sure that we investigate the allegation given, and we also trying to enforce the issue of the whole societal approach so that we can able to tackle corruption in this water sector, Chair. That's the presentation from us, Chair, and we'd like to take this opportunity to thank you for the opportunity. Thank you.
Thank you very much, Mr. Lekgetho, for that presentation, and Ms. Tlesibe as well. I am going to give the members an opportunity to ask questions, if any, either for clarification or direct questions. Honorable Atkinson.
Thanks very much, Chair, and thank you very much to the SIU for all the good work you do. When I see the amounts potentially recoverable or recoverable, I realize we actually don't need tax increases. All we need you to do is bring the stolen money back or prevent the loss, basically. It's just, it's actually quite eye-watering. Particularly on the, on that issue about the campaigns, I think it was saving the water losses or whatever, where there was 2.5 billion budgeted, but actually 4.2 billion spent. I was just wondering, how is that even possible? Because surely in any organization you've got a budget, and once you start to exceed that budget, there should be internal controls that would stop that. So I was just wondering what you found. I mean, that you could actually spend double the budget. What was going on in that organization? Why was that not stopped or picked up? What was the issue behind that? I find that one difficult to understand. Thank you.
I think we've got enough time, so we'll just do a back and forth like this. I think it should suffice. Thank you. Please go ahead.
Okay, thank you, Chair. Maybe, Chair, before I even answer that question, I think I needed to correct something that I reported. The 107 million rand that I reported, it was in relation on the
sand
pellet, yes.
thing.
It was not relating to the sand extraction project. It related to the first allegation. Okay, go back. Yes, it
Secondly, with regards to Proclamation 82 of 2022, I see that here you are dealing both with Lepelle Northern Water Board and Amatola Water Board. So I kind of don't really understand why are you putting the two under the same proclamation? Because I see that there's an issue of the appointment of a civil engineering management company, I think by Amatola, yeah, which was irregular, and its subsequent extension that was found to be irregular. I don't know whether is it because of the same company that it was also appointed at Lepelle Northern Water Board. If that is the case, does that mean you have to use one proclamation for both, for these two different water boards, just because there's an involvement of one company in both instances? Is that the reason why are you putting the two under the same proclamation? And then yeah, I also want to check the progress with regards to 3 officials, SCM officials, that were referred to Amatola Water Board for disciplinary processes. What is is there any progress with regards to that? And then lastly, in slide 14, I think there's also an appointment of a service provider for financial position investigation contract, which was in breach of Section 45 of the Water Service Act. What is that contract all about? Service provider for financial position investigation. What was the whole tender about? Yeah, thank you very much, Chair. Let me stop there for now.
No, thanks, Honorable Chair. I'll start in terms of but maybe also just to add to the question that Honorable Atkinson asked. That's the trend that we see in most contracts, that you find that the budget is this much, and most of the contract end up doubling up. So it's some form of a trend that we see out of it. It's either through the escalation or the variation that they do. And also still on the same water, there's a contract at Lepelle where it also started, I think when we started litigating, it was at 2 billion. Then while we were busy investigating, it moved to 3 to 4 billion. So it means that it just continues on and on. But with regard to the question that we asked, were all our recommendations being implemented? In some instances, the recommendations are being implemented. In some instances, they are not. And we are continue to engage the department and also the water entity regarding the progress with regard to some of the implementation. I know that in the department recently there's a real commitment from the department to make sure that all our recommendations are implemented, and we are working together with them to make sure that whatever we have recommended, it's been done. But we can go back and able to identify some of those that were not implemented so that we can able to share them with the committee. Then with regard to the question regarding having Lepelle and Amatole water in one proclamation, this is depend on how the proclamation it's being written. This proclamation, it relates to Lepelle and water and Amatole Water Board. Why? Because the same service provider or the same services that was offered in the Amatole Water Board was also offered at Lepelle Water, Lepelle Northern Water. So it's the same service provider, and it's the same process that they did. So that's why the proclamation, when it was issued, it's issued for the both water board. So that's how it's been done. Then with regard to the progress for the 3 SCM official at Matole, I'll hand over to Mr. Sibe so that he can maybe give a feedback. Thank you, Chair.
Thank you, Chairperson. Chair, I think we really appreciate the positive comments that we are receiving from the committee members. Chair, we normally give institutions 90 days to provide to the SIU with feedback on our referrals. So the referral that we made we submitted to Amatola was on the 11th of March 2025. So they still have time. So they have not reported back on on the actions, whether they are implementing or not, or what is the outcome of the DC process. So in terms of then the tender for the investigation, the service provider chairperson was appointed to conduct a financial investigation at Lepelle Northern Water. This was after the entity refused to appoint the services of the water extraction technology. It would seem that the entity initially didn't want to involve themselves in this water extraction technology project, and then there was an investigation that was done to look into then the financial investigation process in terms of that. So that was the contract that we are now expected to look at. I hope, I'm not sure whether the Honorable Skosana is satisfied with that.
Yeah, just a little thing. So the contractor, the appointed contractor was like looking at the organization as to whether will they be able, whether are they financially stable, or do they have enough financial muscle to do that particular work? Was it trying to assist them in terms of finances, in terms of their financial positions, or what? Or it was more like sort of an investigation of whether are they using their finance correct or what? Something that I don't understand.
Thank you, Chair. Chairperson, it would seem in this instance that the department had requested both Amatola and Lepelle to utilize the services of this particular service provider for the water extraction technology project. And then Lepelle then refused to do this. And now then there was an entity that was then appointed by Lepelle to conduct a financial investigation into this whole process. It means like they were looking at the financial implication of this project, and therefore then our proclamation is looking into their involvement in the project, as well as then the appointment of this other entity to do then the financial, the feasibility study. Thanks, Chair.
Thank you. Honorable Maduna, time for your exchange. Then will be Honorable Neil May.
No, thanks, Chair. Good morning to you, Chair, members, and colleagues from SIU. And no, thanks, Chair. It's rare that you have time. Usually, in this committee, there's usually no time. No, Chair. I think, Chair, as the watchdog over the public purse, I think it should be worrisome for us, and I think we must. It's one of the things that we must note. I'm noting just I think in the slides where there's 107 million. I'm not sure in terms of the slide number. I'm noting that usually you find out that in this case, when these SCM officials or officials they are implicated in some cases in some other entities, you are told that they are no longer there. But surely, if you go and check where they are, you will find out that they are also in some critical position in another government department. Now, that's a problem, Che. That's a problem because I was umoshala and then ushiye ubese uyahamba uya somewhere else khona uzafike wenzeni if you are not held accountable where you messed up. So I think perhaps I think we need to perhaps start the lobbying process of lobbying Parliament, that perhaps we should look into the issue of doing lifestyle audit to all SCM officials, especially in those that sit in these bid committees, including an intern of SCM. We must look at their lifestyle audit. You would be surprised, Chair, in some municipalities, you find an intern that is driving a GTI. You would be really surprised. I'm told, especially in metros, you find things that you would really be surprised when you look at them. So I think we really need to intensify and to say that let's just do lifestyle audit in all these people that sit in these committees, because the lives that they live are not according to the salaries that they or the stipends that they should get. Two, I think perhaps moving forward, as this scope, so that as Honorable Madlala usually say, we don't come here every time and say ha sobabaza every time. I think one of the things that we must propose is that there must be an establishment of database of corrupt officials. That then, in line with that, we enact regulations or act that will say that if you are in that database, you can't be employed by any other government department, whether local or province or national. Then that database must be public. It must be, because this thing, it's a pandemic now. That's how it must be treated. Because you can't eat money of government somewhere else you live after you've messed up millions and millions. You go and mess up somewhere else. When we're about to catch you there, you leave, you go and mess up somewhere else. It can't go on like that. We need to have some sort of, and I think that is it's from our side. We need to come up with laws that will be able to assist. Because akusizi ukuthi njalo sicela silimane sizobabaza ha because these people, and if you look at that, people that are usually referred to DC, half of them are not disciplined. All of them, they've moved on, they are somewhere else, and so on. So I think this is something that we need to propose, that we need to have a database of all those who have contravened the FMA or the PFMA that will be public, and those people must no longer be employed anywhere else. I think that was as a comment. I wanted to check on those that okay, you said there you are still checking for value for money on the 107 million. Because I'm asking myself if they have issued a final warning. How do you conclude a case of that nature while you don't know the damage that would have done by the decision that was taken by that particular person? That is one. Two, I wanted to check, you said the Department of Water and Sanitation have already opened a case. Perhaps the status, are you having the latest status on it? I think, and please, man, can I get some more in line with what Honorable Skosana was asking? What was that service provider doing? The one of financial position? I'm trying to do, yeah, please, thanks.
Thank you. Before you answer, so just to, thanks for asking this question, for your comments, because they're very important, and maybe let me just appraise the committee of what steps I'm taking in order to kind of assist with the kind of interventions that you are referring to. So the first is that in the next week or so, I will be meeting with the presidency in respect of what system is in place in order to do two things. The first is to address the length of time it takes to vet people. You know, if you recall, we had a huge exchange with the Road Accident Fund about the vetting of officials. And in the meeting, I said, I know that I won't blame you for the tardiness of the SSA. It is clear to me that either the SSA is unwilling or it just doesn't have the capacity, or both. But having been a reference for people applying for jobs in government, I have sometimes been called after the person has already left the public service and they don't even know that the person is gone. And one of those people worked at the Hawks, and I was called 18 months after they started in a critical role. And I was confused as to why they were calling me, because they were hired a long time already. Another person worked in the presidency itself, and I was called a year after they started. So while Cabinet took a decision years ago that people must be vetted, it appears to me that in substance, the vetting does not occur. And one of the things we may need to see is if it does not make sense for the government, if it doesn't have the capacity, it then engages the services of one of these organizations that do the same, right, for other entities. Because in banking, if you've got like a small thing against you, it will come up, Baba, and they will tell you we can't hire you. Things you've forgotten that you once had a fight with Madlala 6 years ago, it comes up. So clearly there is an issue. So that I will be, and the people in the presidency, the councillor in the presidency is already arranging that meeting, the MP who looks after the, so that is in play so that we can address the kind of things that we're talking about. The second one, in relation to that, it's also in the same conversation, is whether lifestyle audits are the regularity of lifestyle audits. So the categorization of people that have to undergo lifestyle audits, as well as the regularity of the lifestyle audits. Because a person may pass a lifestyle audit this year, but then they join in on the fun after. So you now need to regularize. And I'll refer to the banking sector again. So for certain positions, there's something called block leave. When you take block leave, you leave your laptop and everything, and you go away for a week and a half or two. You're not allowed to work or get on the system. Hey, they comb through your laptop, Baba, and your phone while you're gone. And then once you come back, if all is okay, you come back to your job. If it's not, that person never comes back from block leave because there are issues. So what I'm trying to say is that these are not new inventions. They are done elsewhere, and the government should do them for particular functions which are critical. So I just want to say it's something that we are following up, because at some point we need to make systemic recommendations for Parliament, and there's a date we've set aside for the Secretariat to help us with some of those reports. So thank you for raising that issue, because it then gives a chance to appraise the committee on that work. Thank you. SIU, please go ahead.
Thank you so much, Chair. Chairperson, the issue of the 107 million rand is the matter that I've already ratified. The 107 million related to the first contract. Maybe if Mr. Legeto, you can just project that. It's the appointment of then the engineering services. So we've already quantified that one. We know that the value of the contract was 107, and we are taking the whole contract to the special tribunal to set it aside. The only recoverable amount then will be determined by the court in terms of whether there is any just and equitable relief that we can get there in terms of profits. Then on the water extraction, the sand water extraction project, that is where we are still quantifying the value. Yes. And then on the DWS matter where they've opened a criminal case, all that we will then, Chairperson, maybe provide you with an update, because what we have done, we have just supported the Hawks in terms of then the evidence from our side. So I'm not too sure where they are in terms of the status of that matter. And then on the what was the activities of the financial investigation position contract? Here, Chairperson, it is more of a department wanted to pilot a certain project. And then they used both Amadola and Lipele for this contract. Obviously, then this contract was a single source. They were just imposing it to then the entities. And then Lipele refused. And therefore, in that process, they had to come up with a justification. Then they appointed a service provider to at least assist them with some kind of the financial investigation. So that process now, they had to comply with certain regulations, and then one of them being Section 45 of the Water and Sanitation Act. So they did not comply. That's basically it. I hope then it clarifies it, Chair.
So I would assume, thanks, Chair. I would assume that the department would have accepted the reasons from Lipele to not take that service provider that they were given. Because I'm making an assumption that they were funding the project. So they continued funding the project with the new service provider.
Thank you, Chairperson. Chairperson, then we will then be able to determine that within the outcome, the process of our investigation, whether then the department accepted that. But what we have currently is that they actually utilized then, they ended up utilizing the services of this technology.
No, thanks, Chair.
Thank you. Honorable Neil May.
Good morning, Chair. Good morning to the members of the SIU here and colleagues present. Chair, there are basically three areas that I want some clarity on. And that is the transversal contracts. It looks as though these contracts are being used or misused. So my question is, these contracts are negotiated at National Treasury. And the elephant in the room, where I'm also looking at all the monies misspent and the monies that are moved, where is National Treasury's role in all these, in all of this? Because this contract, if you're going to use a transversal contract, it is first approved at National Treasury. There's a contract that is signed, and then it says how you're supposed to use it, and they in fact check all the details, because it has to be like a mirror. If it's a transversal, you cannot deviate from that. So it would be the same service provider, the same everything. That's how I've always understood it to be. So if that contractor was used by, Lepelele, I've got it right, Lepelele. So if they are using that contract, then the Amatola Water Board is supposed to use the same, because it is a mirror. So, and also they're also supposed to only be able to use the same amount of money, the same everything. So all the details are supposed to be the same. And all of this is agreed to and signed by National Treasury. So what is National Treasury's role in oversight, in looking at all of this? It just always astounds me that in all of the money that goes here, left and right, where's National Treasury in all of this? Because these contracts are approved by National Treasury. The second one, and that I wanted to check, was the new technologies extraction. In your investigations, did you see where the source of this new technology extractions came from? Would it have come from the WRC, the Water Research Commission, in the Department of Water Sanitation? Hence, they were pushing for one service provider, because obviously there is the Water Research Commission, who obviously looks at research and new technologies. And that source would have come from that level. And sort of where was the source for this new technology? It doesn't just happen, and people don't just take it, because if you look at the Department of Water Sanitation, they have all these different entities, and one would have thought that they would have, if you follow the thread, maybe it's coming from the WRC. The other area that I'm really interested is the war on leaks, which was a national program. Yet 1.7 billion was paid to Rand Water. Was Rand Water then the implementing agent? Because the war on leaks went through to, as far as I know, all the municipalities. Money was given out for EPWP programs, and I'm looking at the 40 million that is unexplained, and this bill eventually landed up being 4.7 billion and growing. So the question was, is Rand Water, were they the implementing agent? Because if they had received 1.7 billion for this war on leaks, what actually did they do? One entity got the majority of the money, and that is where I have the question. Thank you. That's all for now.
Thank you, Chairperson. Chairperson, I think on the Lepelle Water Board and Amadola, they did not really utilize then the transversal contract. It was more of a regulation 16 capital A, the piggybacking. So then Amadola was supposed to piggyback on Lepelle, but even then the feasibility study was therefore not successful.
Sorry, can you just explain for the public Regulation 16A?
Regulation 16A, it's more of when a state institution has procured the services of a service provider and in a more regular manner, and then the other state institution is actually willing to utilize the same services, or maybe they have a need for the same services, they could then write to the state institution that's already utilizing the services of that service provider, requesting them to participate in the same through then that particular regulation. And in that process, then the other thing, the one that is actually utilizing the services will then agree to it and provide then the new state institutions with all then the relevant documents, to satisfy that we have really gone above the board, we have procured the services of this entity correctly, and then the new entity that wants to utilize the services then will then peruse all then the documents and satisfy itself if then to say that the procurement processes was above the board, and then in that instance, they must then utilize then the services of this entity, but they cannot go above what is actually provided for in terms of the original contract. So, which therefore means if the original contract is for the provision of tablets, you cannot then come back and say, no, now I want to utilize this for something different from the original one. Thanks, Chair.
Can I just ask, I'll come to you, Honorable Marshall. Can I just ask, what controls are there to ensure that you don't have a sort of a abuse of this system where I know half the committee members, as it were, as a supplier, I then go to all of them and I say, I can supply you with this service, but please talk to those guys, and everybody colludes. And what you end up with is a situation where, for the supplier, what would have been a 2 million contract can potentially end up being a 100 million contract, because we keep extending and extending because more entities join in. What limitations are there in the regulation to make sure that that kind of thing does not occur?
Chairperson, I think we can put all the controls, but there will always be then the abuse of the system. What it entails is that the entity that intends utilizing the services of an entity that is procured, that wants to procure an entity in terms of Regulation 16A, there has to be approvals from themselves, and there has to be a budget set aside for that specific service. So I would assume that National Treasury would be monitoring the process, as well as then the HESA when they are doing their audits in terms of those procurements. But what we are as the SIU doing, when we have identified that an entity, let's say maybe Lipele, has appointed a certain service provider through this regulation irregularly, and then there are other entities now that have piggybacked on that. So all then the subsequent appointments emanating from an incorrect process, then they are all, we're setting them, all of them aside. Thanks, Chair.
All right, thank you. I'll come to you, Honorable Madlala. I do think, as a committee, I think with both the colleague from the AG is here, with Treasury and the AG, we just need to get a sense of how much of a handle Treasury has got on the transversal and 16A agreements, because we don't know the extent of it. I'm raising it because in one of your earlier reports pertaining to municipalities in the Eastern Cape, we had an exchange here about a company that had started at 18 million and ended up at 400 and some odd million in the same way. So I don't want it to be lost. So it's something that I've asked the Secretariat to just make a note, and our colleague from the AG is making a note. So we're going to follow up so that we can understand what controls are there, the extent of this, is it being abused, and so on. Thank you. Mr. Lekgetho?
No, thank you, Chair. Just to add on what you're saying, that this process is quite prevalent in municipality, and that is where it mostly being abused. I think, I don't know, is it the regulation or section 32 in the municipality? So it's quite prevalent, where even the contract, they get it and they utilize it for something totally different than what it was originally geared for. So if you look at it in terms of the PFMA, look at it in terms of the Municipal Financial Act also, it's quite prevalent. Thank you.
Thank you very much. Honorable Madlala, you had your hand up.
Thank you, Chair. And greetings to SIU and to colleagues. I am going to, you'll forgive me, I'll deviate just a bit from the presentation. I think we note and welcome the presentation, So, I don't know why Honorable Maitona is laughing. So, South Africa has a problem with water, a serious water problem. And I think it's electricity, then water. If not water, then electricity now. I almost said we may have to ask to have a minister of water. Then I remember that we do. I remember that we actually do have a minister of water. But it is a very critical area that needs to be zoomed into. And if I was at home as a listener, I would, listening to this conversation, I would anticipate an investigation onto the issue of water tankers. And that's why I said I'll deviate a bit, because at the center of part of the challenges, particularly in the rural areas, is the coming up of water tanker mafias. which is a reality, that water is closed in many areas so that people can get these quick tenders to run water tanks. Not that there's no water, it's a different topic altogether. Relating to areas where you need dams and all of that. But there's water, but there's water tank mafias where water is closed and people, because it's quick cash, it's an emergency situation and water is a critical, need. So I wanted to check, that's why I said I'd deviate, because I know it's not part of the report. I wanted to establish why is there no investigation into that, into the water tank mafias broadly, into what is happening in that space, and maybe what would need to happen to start an investigation into that? Because I think it's a national crisis. I think there needs to be a thorough and an in-depth investigation into the operation of water tanks, because I can tell you, many people could come through. Water is closed in different areas, and in some areas people even know, but because these people are feared, they know that there's these people who are closing water, but because everybody is scared of them, and nobody can do anything about it. So at a special investigations unit level, what needs to happen in order to ensure that there's a commission around this issue, or there's an investigation that starts on this matter and resolve that issue? Thank you.
No, thank you, Chairperson. Maybe before I respond to Honorable Matlala's question, there were questions that were not responded to from Honorable Nembe. She wanted to know if the new technology, if it was commissioned by Water Research Commission. And Chairperson, I think I will have to respond to you in writing on that one, because I need to just find out from the team, the investigation team. And then she also wanted to know if Rand Water was one of the implementing agents. Chairperson, we've already reported that this matter is still under investigation, and then we'll be able to advise when we have progressed in terms of our investigation, what were the basis for then the 1.7 billion rand paid to Rand Water. Okay, then moving to the questions from Honorable Madlala, Chair. Yes, I think that one is it's a very serious concern that she's raising. However, the SIU investigations, Chair, are allegations-based, and we will have to get allegations relating to these aspects, and therefore, or maybe if we get a referral from SCOPA, from the Portfolio Committee, or from the Water Department itself. So that's where, because we have to draft a motivation based on allegations before we investigate. Thank you, Chair.
And also, Chair, just to add, if you saw what I presented, that we are establishing the Water Anti-Corruption Forum. In that way, we are trying to build to bring the community and the whole society together, because we understand of such thing happening, and in some instances we are quite far. So establishing such a committee will really, the forum will enable the member of the community to be able to report matters as and when it happens, so that we can able to deal with it. And in that fashion, we'll deal it in many forms, where it's going to be decided whether is it the SIU that can do it, and if it's a criminality, the police are also part and parcel of the forum. They can deal with the matter immediately. So that's how we really want to deal with it. And I agree with Honorable Member that this issue, I think we hear a lot about it, that it's happening, where they even break the tap so that the water doesn't come out, so that they can be hired to go and provide water. So that's why we flagged the water sector as one of the vulnerable sector that really we need to come closer through to it. And we believe that this forum will really help in terms of making sure that we address all these issues.
No, thank you very much. The Department of Water and Sanitation is coming next week. The twin brother or sister of the water tankers is the toilets. So I think in the note, if we were to quote Honorable Bila, they are the men of the match in some places. So we'll ask them, because it's one of those things also where you don't know the extent of the thing. I know that, for instance, where we went in OR Tambo, the water tankers are a money spinner. And the dam that we went to doesn't get built. And I think you can draw the link between the two, because you build the dam, the water tankers are no longer needed. So we take the point. So we'll make sure that we ask them to address that issue, the extent of it, measures, how much money has been spent on it, measures put in place to control the thing. Otherwise, it can be a perpetual thing. There are always people who are happy to break government infrastructure so they can make money. Thank you. Honorable Pila.
Thanks, Chairperson. Greetings to colleagues, the support staff, and the SIU team. Let me join others and welcome the report or the presentation that was made to us this morning. And we really appreciate the good work that the SIU is doing in this country. Chairperson, I understand that there was no specific allegation of corruption that has been received regarding the R138 of 2023 for Rooival wastewater treatment works at Tshwane Metropolitan. But the SIU identified 65 role players for high-level profiling, which include officials, private individuals, and entities. And according to SIU, for their outcomes, only 6 referrals were done up to so far. I just want to check, where are the other role players that we have identified? Are they going to get away with it, or the investigation is ongoing? Because at the bottom there, you have indicated that the interim presidential report was submitted on the 11th of November 2024. Secondly, I want to check under the summary outcomes, the output indicators, the contracts and or administrative decisions were set aside or deemed invalid for the amount of 1.1 billion, if I'm not mistaken. I just want to check that when we say it is set aside or deemed invalid, it means you are no longer going to be able to recover the money that is said there. Thank you so much, Honorable Chair.
Thank you.
Thank you, Chair. Thanks for the encouraging words, Honorable Pina. In terms of the Rooival, Chairperson, I think what we have reported is what we have already delivered. If you recall in my presentation, I said we are busy with a right of replies against a number of employees and entities that we want to now proceed in terms of either administrative action or disciplinary action against them. So there is a lot that is happening there. But in terms of then the report to the president, on a 6-monthly basis, we update the presidency with the update on each investigation. So we always update it. Sometimes we update it 6 months or 8 months, as and when. Then on the summary of, on the 1.1 billion, those are contracts that have already been to court, either special tribunal or high court, and they've been set aside. And the result from that is then the amount of the recovery, which is sitting at the second row, which is 569 million rand. So it would be the contract itself, the entire contract will be set aside. However, in terms of the recovery, we would be then the court will determine maybe just an equitable. Sorry. The court
So,
would-
sorry, can I stop you? So let me just let the members know what's going on. So is it the appropriations committee?
Standing Committee on Appropriation Finance.
So it's the two committees. They need a venue, and we're not gonna move. So I'm just getting. I just need you to understand what this is, because it's. So I'm going to have to step outside and address it. So they need a bigger venue, which is fair. I am communicating through the secretary that we are nearly done. They must give us a few more minutes. They do not want to wait, which is inappropriate. So I'm now going to have to go and address the issue. Sorry, colleagues, so please go ahead, Mr. Lesib. I mean, I understand they need to adopt the report. It's an important occasion, and it's important that the public gets to see it. I get that. But can we also complete our proceedings here? We can't just be chased out. It's silly.
Okay, thank you, Chair. As I was still saying, Chair, the 1.1 billion represents then the value of contracts that were set aside. However, in terms of recoveries, we would then be getting the just and equitable value in terms of that contract or any settlement amount that will be agreed upon by between then the service provider and the SIU and made an order of court. So the matters that are currently at court or at the special tribunal is that 6.2 billion rand that I've reported on. Thank you, Chair.
Just to simplify our civil litigation process, Chair. Normally, what we do, we go to court to first cancel the contract, so that the court can declare that the contract is irregular. And after that, then that's when we go to the next phase, which is just and equitable, because you find that the service provider will come and say, I've delivered. Then that process will determine to say, in terms of your delivery, how much did you spend? Then the determination will be made. And after that, whatever profit that the service provider will have gained out of that, he needs to pay back, because he cannot gain from an irregular process. This is how we deal with the civil litigation thing.
All right. No, thank you very much. Thank you very much. Are there any more questions for SIU at this point? Notwithstanding the pressure from outside. Last one, Honorable Madlal.
Yeah, Chair, thank you. So mine is just to seek guidance, so that I understand properly, because I'm very interested in this thing of water tanks. I don't think that anyone must be feared in this country. So you are saying that what must happen, what can happen either or, is that the committee must make a recommendation, or there must be some level of information of specific alleged, happenings that could be drawn from the public, attached with a motivation from either a member or... I want to just get clearly the options of how we get this thing to start, the investigation. We will ask the department when it comes, but I want to understand from the side, as a member of the public or as a representative, what do we need to do to get it happening as soon as possible? Thank you.
So yeah, in fact, they answer that here because I've also just done the same with them before this meeting. So
No, thank you, Honorable Chair. How we start the investigation, we receive allegation. So the allegation can come from anybody, even the member of the public can come and allege. After we get allegation, we go to the department and say, give us documents because we want to investigate. After we get documents, we will prepare the motivation for a proclamation, which will go to the Department of Justice and the Presidency for the issuing of the proclamation. So on this instance, if there are allegations, I think the honorable member can either direct the member to SIU, then they can talk to us, we can get all the information, or if the honorable member have information, can give it to us, then we can start the process of making sure that we assess whether is it covered. After, if it's covered, then we will motivate for a proclamation.
So I was also going to say to the honorable members, we have an MOU with the SIU. So just before the meeting, one of the things I had with the SIU is about the same, to say we are now going to send you the allegations we get from the public in batches, so that if they fall under an existing proclamation, they put some under an existing proclamation, others then if they need a new proclamation or an extension, then they treat them that way. So I would say, Honorable Matlala, the most efficient way is Sisindombi and Denzel here. Pass those on to them, and then they will package for the SIU. That's the simplest. I get an avalanche of allegations. Okay, honorable members, I don't know if there are any further questions. So the issue is that, as you know, the issues around budget are really important, and the Joint Standing Committee feels that the public should be able to see its deliberations on the matter. I happen to agree. I also think a fair consideration of our discussion is that we were at the tail end of it. I don't think there are any further questions. So what I will do is I will thank both you honorable members as well as the SIU for the work that you've done and presenting to the committee as well. And that you can send someone next week just to observe the proceedings with the ministry. And then we will adjourn at this point and communicate with you if there's anything in between. Thank you very much. Thank you.
Thank you. Thank you.
Can we resume with our meeting? Are you now settled? Are you okay? Okay. I want to be sure that you are settled. Are the cameras working?
They're not yet.
Alan, Mangwen, are the cameras working?
Yes, Chair.
They are working. Eceza bafuna amakamera. Bafuna kucaptureishiwe. Hayi mawuthi ufuna kamera ungathi nezinto zakho. Okay. Thanks, honorable members. You can see what we deal with every day to organize venues. I think today you have a test. This is what we do as chairpersons. You see, we had to negotiate with Honorable ZB here to move faster with this meeting so that he can create space for us, because this was the venue allocated to Scopa. Be that as it may, let's proceed. As we have indicated that in terms of the procedure, because today we are voting for the report, yesterday we considered. We'll start from page 1 until the last page, deliberating on each item, and then at the end we'll put the report for a vote. Okay. Honorable Van Rooyen.
Thank you very much, Chair. Chair, as indicated yesterday, we managed to receive the responses from National Treasury, and as a result of that, we concretized on our submission to this process. Now we've got a complete proposed submission that we want to make. So I'm not sure in terms of this process, how you advise us to approach that, Chairperson. So your guidance will be highly, highly appreciated.
Thanks. As we deal with introduction and background, if you are not satisfied with what is contained here, you will bring the submission, item per item, until to the end. Introduction, Minister's political overview, overview of fiscal framework, until recommendations, observations and recommendations.
Sorry, Chair. It's here.
Honorable Kazi.
Chairperson, it says introduction and background. Didn't we resolve yesterday that it will then be introduction and then background? Then we move to the minister's political overview.
You can have the two together, depending on your style of presentation. The two can be intertwined. On how those of you who are used to writing papers for articles.
Are you saying? What are you saying, Chair?
Sorry, it should not be construed.
You don't want me to divulge what my institution is?
Okay, no, I'm not insinuating that you don't write papers. Thanks, Honorable Kaiser. Okay, Honorable Mlif.
But we did say, Chair, that in the background we must capture the context and the circumstances under which this budget is being presented. I think another honorable member said we have to explain that this is budget, I don't know, 3.0 or 1.3 or 2.5. And that is the context that this budget is developed, because there is reference, even in the minister's speech and in the document, to the budget that was presented in April as the presentation of the fiscal framework unfolds.
Honorable Makoe.
Good morning, Chair. I think the context of this budget is correctly captured. The second paragraph says the tabling of this May 2025 budget followed the withdrawal of the value-added tax rate and the additional zero-rated food items. So it says the background is this budget 3.0 is the outcome. And it follows the withdrawal of the VAT. I don't know what other background we would want, but I would propose that this sufficiently captures the essence of how the budget took place for this period 2025.
Thanks, Honorable Makoe. Where does this thing of 31, 32, 33 come from? Can we use parliamentary language of processing a budget? We are not going to write things which are not out of money bills, the constitution, and later it creates problems for us. The language we are going to be sticking to how we, the template of parliament of reporting. So what Honorable Makuel is saying is that this information that is in red was not there yesterday. And it even acknowledges that this is an outcome also of legal challenges. The VAT, the legal challenges, that's the background why we're here. Honorable Mautwe, Honorable Squatio, Honorable, let me take hands like Mautwe, Squati, Mulife, Beasley, Lechayane. We are on introduction and background.